SJC-11604, John Doe, number 3839B, Sex Offender Registry Board.
Thank you, Fran.
Good morning, Your Honors. May it please the Court. Matthew Coase on behalf of the appellant, John Doe, 3839. It's well established that our law treats juveniles differently than adults. When a child is accused of a crime, he is subject to special juvenile proceedings that focus on rehabilitation and not punishment. In order to further the rehabilitative goals of the juvenile system, the proceedings are done in private and the adjudications do not become public. This is all in an effort to avoid the attachment of a criminal stigma to a juvenile.
And this is done specifically because the legislature has designed it that way, correct?
That's correct, Your
All right,
Honor.
there's no constitutional requirement that this juvenile system be confidential or focus on rehabilitation.
Well, Your Honor is correct that the juvenile system is created by statute. However, there is a great deal of jurisprudence from both the Supreme Court and from this court that recognizes those. But to specifically answer your question, I'm not aware that it's a constitutional requirement.
Right, and so when the legislature passes a statute like the registration statute or the classification statute includes juveniles in it, they're actually focused on public safety factors rather than sort of juvenile justice factors. Isn't that true?
Well, that would be true. The outlying factor of the registration statute is specifically to protect the public from the danger of recidivating sexual offenders. What sets this particular case apart from the general cases is, of course, Doe's age at the time of his offenses, which was 14 and 15 years old. And it's also important to point out that his offenses occurred prior to the enactment of the registration statute. When the statute is applied retroactively in that manner, it undermines the objectives of the juvenile justice system.
But the legislature has specifically said we wanted to apply that way because in this instance our focus is on public protection, not on juvenile justice rehabilitation stuff, right?
Well, that's correct, but it also operates as an ex post facto punishment on the offender who's required to register.
Haven't we said this is a regulatory statute, not a criminal statute?
Well, I think Your Honor is referring to perhaps the Commonwealth versus Bruno case that refers to the SDP Act with respect to...
We haven't said the SORB statute is
The
regulatory?
DOE 4725 or 8725, whichever it is.
Yes, it is regulatory. However, this particular situation, again, is different because of Doe's age and because he's being required to register after or prior to the enactment of the statute. Again, it operates in this particular case as an ex post facto punishment.
What do you make of SORB's contention that you're ignoring the fact that he was an adjudicated SDP in 2003 after SORB legislation was enacted?
I recognize the board's argument as an argument in favor of jurisdiction. They're basically saying that registration can be triggered as a result of the conduct and as a result of his SDP commitment. Our position in this case is that the entire statutory scheme retroactively punishes Doe for his conduct. The hearing examiner specifically looked at the conduct in assessing Doe's risk. It looked at the conduct from 1989 and 1990 to make the determination that he was a level 3
But you have
offender.
to accept as the premise of that it is really punishment, right? That registration equals punishment, don't you?
Well, the first prong of demonstrating an ex post facto punishment is retroactive. And then the second would be that it would be punishment. In this particular case, under these factual circumstances, which are quite rare, it does amount to punishment because of the significant differences between juveniles and adults and the way that they're handled in the justice system. For example, Doe, when he initially made his admission and was adjudicated delinquent, he was not aware of the registration statute. That did not come into play until several years later. He did
May not have been aware of the sexually dangerous person statute either, which really didn't come back into play until about 1999.
Well, that's correct, Your Honor. But you know, as far as I'm aware, the court has not dealt specifically with you know, a retroactive application of the Sexual Dangerous Persons Act with respect to juveniles as well. So I think we're still here in uncharted territory with respect to juveniles who are adjudicated prior to the enactment of the statute. As I was saying before, this particular, or Doe in this case, did not have knowledge of the registration requirement. Had he known of this new legal consequence, he might have been able to negotiate a better deal that did not require registration. He might have been able to, or might decide to take his case to trial as a result of avoiding this punitive measure.
After he committed the first offense, and he was placed on probation, which you think would discourage him from committing another, he actually assaulted 2 more victims. And that's what resulted in his commitment and ultimately in his, to commitment to DYS and ultimately to his commitment as a sexually dangerous person. So there were lots of points at which he could have been deterred. You'd say if he knew he'd have to register, that would have made a difference?
Well, it could have made a difference with respect to how the case was handled initially. I think that we could make an analogy to the recent Moe decision from this court from this year that looked at the retroactivity with respect to a certain amendment of the registration statute that required post-July 2013 offenders to be placed on the internet. And what the case did is it looked to situations where an offender relied upon the fact that they were not going to be put on the internet in making their decision whether or not to challenge that level 2 classification. And again, the same could be said here with respect to the initial adjudication. Doe could have decided that he wanted to take his case to trial and avoid registration altogether, but he did not have that option. And I think the subsection of the statute, or Section 178E, kind of addresses that and demonstrates that the legislature actually perceived registration to be punitive or at least harsh with respect to juveniles. As this court knows and heard about earlier this morning, some juveniles are capable of, or can at least seek to be relieved from registration altogether.
So can adults. I mean, the legislature didn't distinguish in 178EF, did not distinguish between juveniles and adults, did it?
Not that I'm aware of. You are correct. Certainly an adult offender can seek relief from registration as well. Any attorney that handles cases in this particular realm who's knows that in any classification proceeding, you always seek a relief from registration. With respect to how many times the board actually grants relief from registration, I can't speak to that. But you know, the fact of the matter is, Doe was not able to seek relief at that particular point. He did seek relief at his classification hearing, but that was.
But he received, when he was adjudicated, he was he wasn't put on probation, was he?
My understanding is he had the first adjudication, which I believe was in 1990, and I believe he was put onto probation. When he had the second adjudication in 1991, he was committed to DYS.
Right.
And
So,
then-
so I guess I'm just saying, even if this were later in time, I don't know that 178EF would have been available to him anyway.
Well, that may be true, but, you know, he didn't have any safety valve with respect to, you know, registration at that particular time. The other important thing is when the court is looking at whether registration is punitive in nature, there's 7 specific factors that are outlined and commonly referred to as the Mendoza-Martinez factors. I won't go through them one by one, but I think it's in particularly important to look at what the affirmative disability and restraint is upon Doe. This court has said on numerous occasions, even within the context of a level 1 offender in the Doe 8725 case, that registration is intrusive, continuing, and humiliating. It makes things public, at least in Doe's case, it makes things public that would not otherwise be made public.
I take it at this point, your argument is directed at the Massachusetts Constitution, because the U.S. Supreme Court has pretty much resolved this.
Well, it's resolved it with respect to adult offenders. I don't believe that the United States Supreme Court has directly addressed it with respect to juvenile offenders.
Okay,
Your
well,
Honor, might be-
Your client actually is an adult, right?
He's not currently a juvenile, no. He's currently an adult.
Yeah, I'm a bit perplexed. Let's assume all that you say is true with regard to the serious adverse consequence to a person to be registered. It's certainly less adverse than being incarcerated as an SDP, and we don't apply ex post facto with regard to STP. So how can we apply ex post facto to registration?
Well, Your Honor, I think that can be distinguished because SDP is not applied retroactively to adults, but I'm not aware of any cases in the Commonwealth that address it specifically with respect to juveniles.
But why would the ex post facto part matter depending on the age of the person involved?
It's important because of the significant differences between how we adjudicate juveniles as opposed to how we adjudicate adults. Again, in juvenile proceedings, it's private. The adjudications do not become public. But here, under this registration scheme, we post his picture on the internet, we give his address to everyone, and we outline his offenses. Those offenses, generally speaking, would not have been available to the public but for the registration.
But that doesn't seem to be an ex post facto argument. That seems to say that the legislature was foolish in applying registration to juveniles, but for that, we'd have to evaluate it by rational basis analysis, wouldn't we?
Well, the argument that I'm trying to make is because the registration statute deviates from the juvenile justice system on this particular standpoint, it is particularly onerous and particularly burdensome on juveniles that would not ordinarily be the case. That they would not, they would be shielded from having their offenses made public, and which in turn affects their ability to find employment, their ability to find housing, subjects them to other collateral consequences, such as being the victims of threats or intimidation or violence. So as a result, again, Your Honor, the fact that someone is a juvenile separates this particular case from all of the other jurisprudence that says that the registration statute is not retroactive or not punitive. Finally, we want to look at what the state's articulated purpose for the statute is, and again, it's to the articulated purpose is to protect the public, but we have no real hard data that demonstrates that the registration of these individuals does in fact protect the public. And we also know that juveniles, as a matter of course, recidivate at much lower rates, and they are much more amenable to treatment than adult offenders.
All right, thank you.
Thank you.
Good morning. May it please the court, William Burke on behalf of the Sex Offender Registry Board. This plaintiff is subjected to the Sex Offender Registry law because he was found to be a sexually dangerous person in 2003, 4 years after the enactment of the Sex Offender Registry law, and based on a current risk assessment at his administrative hearing. Let's make clear, this isn't the juvenile, like as Justice Spina and Justice Cordy indicated earlier, made a mistake and presented well to the juvenile court judge. This is an individual who in 2003 was found to be a sexually dangerous person. He was looked at twice, in 2003 and in 2010, by experts when he was 28 and 35. They still found that he suffered from a mental abnormality or personality disorder where he needed to be civilly committed at the Massachusetts Treatment Center.
But he's been discharged.
He has been discharged. He's been out approximately a year. After his July 2010 SDP, they found him to remain as a sexually dangerous person. He petitioned again. During that petition, the two qualified examiners came back and said he was no longer sexually dangerous. He was released under the Johnstone case. So he is currently
But the
indicated.
classification hearing for the SORB happened, what, in 2010?
Correct. It happened 10 days prior to his Section 9 trial. So the board attempted to conduct the hearing as close as possible to his earliest possible release date, which would have been that July 2010 Section 9 trial.
Are you conceding the ex post facto issue that, at least as to his juvenile adjudication occurring before the SORB statute was enacted, or are you saying that we don't have to deal with that because in this case he was adjudicated a sexually dangerous person after SORB was enacted?
Yes, I don't think you have to deal with it because he was found to be a sexually dangerous person in 2003. Notwithstanding, this is not punishment. As Chief Justice Gantz indicated, if civilly committing an individual for a day to life isn't considered punishment, registration should not and cannot be considered punishment under these circumstances. And in Doe 8725, the court confirmed that and indicated that.
If the classification was done before the most recent assessment that on which he was released, because the qualified examiner said he's no longer sexually dangerous, right? Is there a way for him to have the board relook at that level 3 classification?
Yes, he can. Currently, as we stand, he can file a motion for reclassification to have the board relook at his case and his circumstances. He's well within his rights under 803 CMR 1.37C. So he
Is that
can.
at any time? He doesn't have to wait for a certain number of years?
The only disqualification would be you have to wait 3 years from the date of your final classification. So
So that was, but he's over that already.
exactly. He can apply now for relief, for termination, for reclassification if he so chooses at this time.
Is that, so he could actually apply now for termination of his classification as someone who needs to register? Or just can he file for a lower classification?
He could file for termination. The reason why is because he's adjudicated delinquent as a juvenile, and that's the distinctions under 178EF.
But you still had to wait 10 years, no?
No, and if you look at 178EF, there is a distinction between adults and juveniles.
Right, right, because certain things aren't convictions, so you don't count them for juveniles. That's one
Correct.
difference.
So there's, any offense can be relieved for a juvenile. Adults, no. That's the distinction under 178EF.
Wait, where is that? I'm sorry, you've lost me here.
Chapter 6, 178E,
Got it.
subsection F,
Got it.
when discussing when the court can relieve an individual of his duty to register.
Is that a
But no, that, wait a
Yes.
second.
Because they aren't convictions. So,
Correct.
so if it's an adjudication for these various crimes that would preclude an adult, the juvenile can still seek that.
Correct.
But that's one thing. But, okay, now you're classified and he's got a level 3. Where do you get the 3 years? I thought you had to wait 10.
Well, 3 years he wants to apply for, at this point, he's a level 3, obviously.
Right.
He would be looking for reclassification.
So it isn't that he can't get out from registering yet.
I believe he could.
After 3
because
years?
10 years from, he was adjudicated delinquent in 1990.
Oh, it's from the adjudication as delinquency, or is it from the classification?
I believe it's from the adjudication, I believe,
Okay, okay,
100%.
all right.
I'm not sure about any of that. Okay, I don't understand.
Notwithstanding, even if this court looks at the retroactive nature of this statute as it applies to this plaintiff, I think it's reasonable. And I think that's what this court did in the Michael Moe case and also in Doe 8725. They looked at the retroactive nature of this statute. And I think the court looks at this from 3 perspectives, obviously. The nature of the public interest that motivated the legislature to enact a retroactive statute like the sex offender registry law. And clearly the purpose behind the sex offender registry law is public safety. It's, the emergency preamble talks about the danger of recidivism posed by sex offenders who commit predatory acts characterized by repetitive and compulsive behavior to be grave. And that's this case. This is exactly what happened in this case. He was adjudicated delinquent for raping a 6-year-old girl while on probation. For that offense, he sexually assaulted 2 more 9-year-old girls. So this is exactly what the statute was enacted to do, is to protect the public from individuals like this offender.
Was he adjudicated an SDP for the same conduct, or was there further conduct?
It's from the same conduct, from the offenses, the adjudications for the 6-year-old child and also the 2 9-year-old girls. So
There was no further conduct?
no further conduct.
And that conduct ended when he was 17?
Correct. He was committed to DYS, and they filed 4 extensions, I believe.
Obviously, those extensions had some grounds, which may well have been part of the SDP. He didn't commit any more criminal offenses.
No more criminal offenses.
But
Exactly.
wasn't there, if I recall from the record, there was additional information about other offenses, that weren't.
Correct.
for which
Correct.
there was no
While he was at the
prosecution.
treatment center, he admitted that he had, I believe,
7
7
victims.
additional victims that he had
Right.
sexually assaulted, but he was only adjudicated delinquent on
Right,
3.
but
But
those
these
were
were-
considered.
And these were all when he was under the age of 17?
Correct.
So I guess my point was that there was no conduct after the age of 16 or 17, charged or uncharged, that formed the basis of the SDP.
Correct. He was committed, so unless he did something while he was in DYS commitment or at the treatment center awaiting probable cause, he wasn't, in the community.
Okay, so
able
he was
to-
out of the community for that entire period of time?
Exactly. After his last extension, they sent him to the treatment center where he was eventually found to be an SDP in 2003. So he hasn't
and
been in the community. He's just recently got out, obviously,
Right.
a year ago. So the second perspective, the nature of the rights affected, clearly registration it's not fundamental, it's substantial. The board recognizes that, but the plaintiff's due process rights were protected here. He challenged a preliminary recommendation. He presented evidence, detailed decision. He went to 30-day review, appellate review. We're here today. And again, I think the board's regulations do take into consideration the unique circumstances of juveniles like this case. The preliminary recommendation.
Is there a conflict? He'll be he's level 3, so there'll be internet dissemination.
Correct.
Will his prior juvenile adjudications be included in that?
Yes, it will be.
So is there any conflict with the confidentiality of juvenile adjudications and the level 3 registration obligations?
I don't believe there's a conflict. I think the public safety in this case outweighs that conflict here, given the nature of his offenses.
But putting this aside, let's say that a juvenile commits horrendous crimes and is a real danger, not sexual danger, whatever. You still can't, because there's a public safety issue, release the juvenile records.
Unless the legislature passes a law saying you can.
Correct. I mean, the legislature clearly in classifying offenders and what can be provided to the public as a result of classification, it's contained within our statute of what the board's required to give out as a result of the level after that hearing is conducted to determine what level that individual is in these cases.
So you say the authorization for being able to publish that information is what?
Statutory.
178D?
178K, I believe it's K. Let me see. The internet. I don't have it off the top of my head, but it's the internet portion of what's able to be disseminated to the public based on the different levels of offense. And clearly, juveniles in this case, they automatically terminate in 20 years. There is scope and extent with respect to juveniles. And this offender, like all juveniles, could have been relieved by the hearing examiner at the hearing. The hearing examiner could have said, I find he's at no risk and no danger, and relieve this
20
offender.
years from what?
From the offense?
No, this is going to be 20 years. This is the catch of this one, obviously. It's 20 years from the release from his SDP, so he still has 19 years in this case. Because if it was from his offenses, I believe in like 2016, he would be automatically terminated 20 years out.
And that's by statute too?
Exactly, yes. Yes.
Thank you.
Thank you very
If there
much.
are no further questions?